Every day, USA find themselves ladies and gentlemen. It is Saturday. It is Catterday. I am your lone wolf Oosel. We are here. I have court cases. And as far as I'm concerned, we're going to watch them. At least those of you who choose to. We'll start off with the Amish AI Sov Cit defense nonsense with Judge Middleton. We're going to move very quickly. Well, actually, we're not going to move too quickly. We're going to trudge our way through today's cases. We'll move from the Amish into another zoning case that we've seen in the past. We'll get an update on that one, and then we'll move from that into a landlord-tenant case we've seen a lot about with an old Miss Melvin who's not present with dead mice in court today. All starts right now.
This is hearings in two separate cases. In the matter of Colon Township versus Alfred E. Yoder and Joanne Yoder. You're Alfred Yoder?
Yes, sir.
And you're Joanne Yoder?
Yes, sir.
And the township is represented by Mr. Lance Thornton, who is also present. Mr. Yoder and Mrs. Yoder have represented themselves throughout these proceedings. They have a right to represent themselves. I recommended they get counsel. They do have some legal advisors, but they are here on their own behalf. I had hoped to get to the end of the finish line here in this case, but we aren't there yet. We took a lot of testimony through the spring and summer. On October 15th, we had a final hearing, and the court issued an order for indemnification / restitution. And another order following civil contempt. Then there was another order issued on November 5th, and another order on November 5th regarding each case. Denying the motion to set aside the default and the original order for the cost portion of this. Mr. and Mrs. Yoder have filed a number of motions in each case. Kind of trouble. Ordered them all out. But I have before me a proposed order on motion for sanctions, order granting defendant's motion for sanctions and finding fraud upon the court. Proposed order granting defendant's motion for reconsideration, vacating void portions of prior orders. And then supporting that is entry to objection to entry of order and notice of inaccuracy under MCR 2.602B3. And then they filed a brief in support of application of law, recognition of compliance and void judgment doctrine. And a brief. And then they filed something called a declaration of AI forensic analysis and findings. I think AI assisted in preparation of these. Defendant's motion for reconsideration, correction of factual constitutional errors, and motion for sanctions and fraud upon the court. So I think there's actually 3 actual motions. Motion regarding cost, motion for reconsideration and correction of factual orders, and motions for sanctions and finding of fraud upon the court. Mr. Thornton got the same set of pleadings I did. The ones I quoted from were from the 25040 case, and I believe there's a parallel set in the 25533 CZ set. So they filed a motion for reconsideration on the other matters, and the court can't simply ignore it. So we set them for hearing. Who's going to speak for you? You, Mr. Yoder? All right. I think we've resolved our question about all rise. I guess the simple solution is just people that don't object just come in after we start and sit down, and then we avoid the whole rigmarole. All right, Mr. Yoder, what do you want me to know?
What don't you understand?
Well, I don't understand most of it, to tell you the truth. What are you asking me to do?
Well, I thought if I can understand it as a dumb Amishman, I got to the point where it actually makes sense.
I wouldn't use the term dumb Amishman. They're some of the cleverest people I've encountered, but so call me a dumb judge. So
No.
you filed these 3 motions, and I don't exactly know what it is you want me to do.
All right, let's run with the objection to entry of order and notice of inaccuracy under MCR 2.602.
All right.
According to the transcript from the last hearing, we were ordered to pay fines at a cost.
Yes.
All right. And this letter that I got, right.
It's a shame because it's like a blank space. It hasn't been taken.
The defendant shall pay restitution, Colon Township. Restitution amount leaving a balance of $2,449. Then the court said within 30 days, some reason or other, this paper that is left blank. This isn't the paper that I wanted because it's on that paper that we're held for civil contempt. We owe the township for incurred pecuniary losses and that restitution is owed. That's not even what the court said.
Well, I went back and watched the video. I've left these up. Usually I take things down on or after 30 days so I could review things. And I looked at what I said on the 15th. And it may be just a matter of semantics, but this payment is going to Colon Township.
I realize that.
Okay.
I have the transcript from that court date. Not with me, but we have the transcript.
Oh, very good.
And that's not the wording from the court.
Well, it's the wording that's in the order. The court stands by its order. So, Mr. Thorne, do you wish to respond to that?
Sure. Defendants object, and part of the problem is their objections address two different orders, one in each different case, but they've got just one objection. So they object that to the finding that defendants committed civil contempt. The defendants did commit civil contempt, and the court made such a finding. Defendants further object to the language regarding the township incurring pecuniary losses and the restitution, that restitution is owed. Again, the court did make these findings. The court may have said costs, but it's not just taxable costs, it's restitution. And my motion for the restitution cited the MCL statute, and that's in the order. And the court agreed and ordered it under that statute. And that is for costs and restitution to the township. So we're not arguing over the amount. That was clear what the court ordered. Although I did the follow-up order because Your Honor had marked up an order that I had pre-prepared that
Looked pretty bad.
yeah, so I clarified it with more time after the hearing. So again, the court did make those findings. So whether you call them costs or restitution, it was clear under what statute the court was ordering it, and it was clear that the court did order it. The defendants complained that the orders were not circulated before they were filed. I'm assuming they're saying before they were filed with the court. Well, the court rule doesn't require that they be circulated before they're filed. They were filed with the court under the 7-day rule and mailed the same day to the Yoders. That's the whole idea behind the 7-day rule. There is no requirement that the proposed orders be provided to the Yoders before they are given to the court. The court waits 7 days for the Yoders to present their objections. And then if no objections are received within that 7-day period, the court signs the orders. And in this case, the Yoder's objections come in after the 7-day period expired, but and the court did go ahead and enter the orders. So I'm not even exactly sure.
Well, the order complies with what I ordered.
Exactly.
And the court speaks by its written orders. And I went back and looked at what I said, and I tried to explain. I lowered some things that you had requested. We came up with the amount of $4,449.94. I allowed that the bonds that the defendants had been posted could be applied against that amount, and the amount remains the same, $2,449.94. So the defendant's objection to entry of that order is denied. Mr. Thorne, you can prepare an order to that effect.
Can we fill in the blank on the order as part of this order denying and how many days they had to pay the $2,449.94?
In let's see. Yes, it should have said 30 days, but now an additional, so today is the 3rd. I'll make it 30 days from today. So the original order was within 30 days of October 15th. The amended order came in on November 5th. Was sent out. And so now I've reconfirmed it. So November 5th to December 3rd is 28 days. Paid within 58 days, amended. Defendants have 58 days from November 5th. Pay the balance. The $2,000 may be transferred.
That's been received, Your Honor.
All right.
The court has transferred that to the township and I delivered them their check. So.
All right, you have essentially 30 days from today to pay that $2,449.94. So Mr. Thorne, would you do an objection denying or do an order denying that motion and granting the defendants 30 days from today to pay that amount? Yes,
It's not
Ms. Young?
necessarily the pricing, that's right.
Yeah,
That was correct, but it's the way it was worded here and then, but the things that he reworded differently, that hits us because it's like, it's not exact, it's not how it was given in court.
well, as I said, I
Reworded
listened to it, and the statute entails costs and restitution, and costs go to the court generally. In certain types of violations, they go to the city or village. Fines go to the libraries. That's a whole different can of worms in criminal cases. But this is a zoning violation matter with a civil contempt. So what I wanted to make sure was that the township got the money rather than the court. And that order makes that happen. And so I'm satisfied. And I did try to explain it, and maybe I didn't explain it very well. But that original order stands. You have 30 days from today to pay the amount stated, which is $2,000. $449.94. That's the first motion. Let's take the next one.
What date does that come up to?
Well, 30 days from today would be January the 2nd. First business day of next year. All right, that's this one. Next we have, trying to keep my motions. Motion for reconsideration and correction of factual and constitutional errors.
Your Honor, are you understanding it, what we gave you, or do you want us to read everything?
Well, no, I certainly don't want you to read it. I read it, but could you help point out exactly what it is you want me to do? I read it more than once. Some of this is AI generated, and it It's hard to track. It doesn't look like a normal legal pleading that the court sees. So let me ask, which I would ask any party, you filed a motion. What is it you're asking me to do?
Right, what, how can we have a case, a legal case, if there's a whole bunch of illegal stuff going on in it?
That's the essence of your view.
Exactly.
Okay. Now, as I've recited a couple of times, I came into this matter in midstream.
Yeah, I realize that.
It had been going on for some time, and you were given a notice of default. You did not appear. Default judgments entered. You did not move to set the defaults aside. I did not grant a motion to set the defaults aside, and I allowed both default judgments to stand. That happened all before I got here, and then I've been dealing with everything since then. And there's a difference between being ignorant and being dumb or stupid. You're not dumb or stupid, but people that aren't lawyers don't always understand the law. Sometimes the lawyers don't understand it, maybe judges too. So this stuff is complicated. And so you try to step back and look at it as a large framed picture saying something looks out of whack here. And then when you get into it and you take all the testimony and we spent all the time that we did, I made the finding that I did. And I stand by it. And this is a recent phenomenon, particularly with AI assisted. You go through a long, arduous hearing, spend time at night, evening, going over everything, take all the testimony, make a ruling. Then they file a motion for reconsideration, saying, well, I don't want to do this all over again. I already made my ruling. I don't want to go through the whole process in a reconsideration. Mr. Thornton, what have you made of this motion for, and I think they're parallel motions in both 4-0 and 533 case, the defendant's motion for reconsideration and correction of factual and constitutional errors?
Well, first off, the township opposes all the recently filed motions. And I'm a little confused because when I first got the 40-some pages of filings on October 31st of 2025, I contacted Your Honor's office because I was wondering what we were going to do today on 12/3 of 2025, since there were additional motions filed in addition to the objections to the two orders. So, and I communicated by email with Your Honor's secretary, and I was informed, and I have copies here if Your Honor wants to see them, that the last response on November 5th was the hearing is just on the objections they recently filed to the orders.
What was intended, we were just gonna hear all the motions, so I'm not sure if something got lost in the translation.
So
you're claiming you don't have notice for hearing on these motions?
I don't, based on that, I didn't file a response to the motions. I'm wondering how many post-judgment motions, the court's going to allow the defendants to file. I don't know what we're up to. I would have to sit through and go through the files. But there's been several in both cases, and all have been denied. And so, yeah, our position is, no, I'm not, I didn't file a response. I'm not.
Well, every time they file something like this, with the aid of their assistants or AI, it costs the township thousands of dollars to respond to them.
Correct, and especially when we get them in the form of 40-some pages, addressing with the two cases mixed together, and the documents mixed together, and I have to take the time to sort through them, which I did take the time to read through all of them. Nothing has changed. The same arguments are being made that the court's denied in the past. So based on that and based on the email I had received from Your Honor's office, I didn't file written responses. The township does object to the orders and opposes or objects to the motions and opposes the motions. The judgments have been granted. The defendants have not shown anything that would require the court to overturn its rulings. And as the court has stated in the past, if they didn't agree with Your Honor's in this court's rulings, they have the right to appeal.
Yes.
I'm not even sure where the appeal would stand at this point because of all the subsequent motions that have been filed post-judgment. So I guess if the appeal occurs, we'll have to sort that out.
Well, all right. Regarding this first motion for reconsideration and correction of factual and constitutional errors, it's got some exhibits attached to it. I don't comprehend it very well. Township objects to it, and I'm gonna deny it, and defendant can appeal that to the Court of Appeals with everything else.
Your Honor, and could I add for the record that all of these motions that get filed, the one thing the defendants do not do is set them for hearing.
Yes.
And get a hearing date and send out a notice of hearing, which is required of them to do. I realize they're not acting as their own attorneys. We all know somebody else is acting as their attorney, but that is their obligation under the court rules, is to set it for a hearing, prepare a notice of hearing, and serve it on me so I know what we're here for on any given day.
A fair response. In the courts, I don't know what, just a minute, I don't know what they would do in circuit court. In Judge Noacker's day, people would file something in the circuit court file and nobody would even look at it. It'd get put in there and it'd be a year and a half later and the parties call up and said, hey, what happened to my motion? I'm a district court judge sitting in this zoning matter, which I do lots of these, but it's in a circuit court context with the circuit court county clerk being responsible. So I have to make sure that I'm complying with how they do things. But I said it. I didn't want to just leave it in limbo. So in each case, I've set these for hearing. And the motion for reconsideration and correction of factual errors is denied. You can appeal that also to the Court of Appeals. I don't understand it. Township objects to it. And if you can get the Court of Appeals to confirm it, then maybe they'll understand it better. They will not be lax upon the filing of the rules. They've got very strict rules on filing and briefing and deadlines. So that appears to be the third motion. That's in both 4-0 case and the 533 CZ case. Now, this one, I didn't understand.
-9.
Motion for sanctions and finding of fraud upon the court. Um, Again, I'm not exactly clear what that is. The two cases kind of intersperse. But this also has to do with the money, the 2,499.94. And you object to that order and you want finding of fraud. Again, I'm not sure I completely understand that. Mr. and Mrs. Yoder, what are you asking for in that case?
Well, I guess the way I understand the laws, if you read all this stuff, if the judge says one thing and the attorney writes letters stating other things, that's technically fraud. In my book, I'd say he's lying. Plain English. Like I said, we have the transcripts, and no, that does not match up with the transcripts.
All right.
So in plain English language, that's fraud.
Now, this order, this motion is a little better because it has relief requested. You're asking me to find that plaintiff's counsel proposed order failed to conform with the court's oral ruling and was submitted in bad faith. 2, to declare the October 22nd, 25 written order void to the extent it includes findings or language not stated on the record. 3, strike any reference to civil contempt, restitution, or pecuniary losses from the case record. 4, impose sanctions, including defendant's reasonable cause for preparing this motion and correcting the record. 5, direct plaintiff's counsel to show cause why further disciplinary action should not be directed to the Michigan Attorney Grievance Commission for violation of conditions of the canons of ethics. 6, grant such order on relief as just and necessary to preserve the integrity of this court. That I can understand. I don't know if that was AI generated or otherwise, but I don't find that he committed a fraud. I don't find that the order was issued in bad faith. And in my earlier order, I've declined to strike those matters. And really, it's a matter of semantics rather than the amount, as I indicated. And I looked at the record from that day and tried to explain that amount I calculated after hearing evidence. I deducted the amount of the bonds from that, and I wanted to make sure that the money went to the township rather than to the court or the state of Michigan. So your motions for sanctions and finding a fraud upon the court is also denied. I don't find there was a fraud on the court. I don't think Attorney Thorne acted in bad faith. He was trying to interpret my ruling as well, and the order accomplished that.
Your Honor,
Yes, sir.
can I call somebody to witness?
No. You can't. This isn't a testimonial hearing. I tried to get this case to the finish line, and to your credit, you have ceased birthing operations at Mama's house. We're working on getting the other building in a position where you can utilize it. You may wish to open your enterprise in another jurisdiction that would welcome it. I don't have any objection to that. But I wanted to bring this case to a close. I found my default orders remained in effect. I tried to calculate what I thought was a fair amount, which is much less than their actual costs. And I want to keep treading the same water. So I meant what I said on October 15th and in my previous rulings in this case. So each of your motions, motion for sanctions is denied, motion for rehearing is denied, correction of constitutional errors, and the objection to the order is also denied. Mr. Thorne, if you would prepare those, then you can appeal this to the Court of Appeals. My feelings won't be hurt if the Court of Appeals disagrees with my ruling in this matter. I didn't seek this matter out, it landed on me. And I want to bring it to a close. So each of your motions was filed. You didn't notice them, the court noticed them. So the township was a little bit confused as to what exactly we were doing. I may have added, I'm not out to look at that email response. Anyway, all three of your motions, the best one was the last one, but at least the best understandable one from my perspective. So we'll send you a copy of those orders. You have until January 2nd to pay the balance of that. We'll call it restitution. And if you wish to appeal it, I wish you all the best.
Your Honor, I would like to comment.
Yes?
The allegations of me committing fraud against the court and making misrepresentations to the court are offensive. As I stated before, we all know the Yoders are not drafting what they are signing and submitting to the court. The documents the Yoders are signing are being drafted by someone who is providing legal advice to the Yoders and who is covertly acting as their attorney. However, that person is ignorant of or doesn't understand the court rules or court procedure. And by signing those documents, everything stated in those documents becomes the Yoder statements and legal arguments. I practiced law for 36 years, and I have never knowingly misrepresented anything to this court or any other court. And the Yoders allegations, again, are extremely offensive. Your Honor made the findings and rulings that are set forth in the orders, and Your Honor signed the orders I submitted. I assume Your Honor would not have signed the orders if the orders failed to represent your findings and rulings. So I do appreciate the court's comments today.
All right, and they did. And you and your efforts have the respect of this court. You do a very fine job representing your client. Yes, Ms. Yoder?
So we are getting help from different directions, yes. AI has been our crutch. Best thing that we could, best resolves that we could get. And AI is to the Truth Act. It is not illegal. That is legal. And AI does know.
Well, I didn't say that it was illegal. The legal world hasn't quite caught up to AI. Some of it can be very helpful. In fact, it's gonna dramatically alter the practice of law. Right now, it hallucinates. It finds facts that aren't real. It makes things up. And parties have been filing stuff without properly vetting them. Some attorneys and even some judges have gotten profoundly embarrassed by not vetting or verifying the information filed in the briefs. I didn't make a finding that your information is false or a hallucination. I simply disagree with it. As this gets better, it is going to change the way we do everything in the world. I was at the judges conference in May in Detroit, and a speaker spoke to about 600 judges with an AI presentation on legal briefs, and we were stunned. So yes, it's certainly not illegal. It has its uses, it has its drawbacks, but I've made my ruling. I want you to pay that money by January 2nd to the county clerk. The matter will be concluded. If you wish to appeal it to the Court of Appeals, feel free. Yes,
Your Honor.
yes, sir.
What did he say that happened to him when we filed that he had brought up on the court?
I don't remember, but you were here. I don't want to get into a
I
personal.
don't remember what the name he had for that.
Well,
It wasn't humiliated or whatever he called it.
He was offended.
Offended.
Yes, that sounds like a good word. If I was him, I'd have been offended too.
How does he think that we're feeling with what we've got going on out there?
All
And
right.
we tried to be a plain person, live a plain life. We even asked him and his safe-built guys for advice, and this is where we're sitting. Now, you think we're not humiliated?
I certainly would say frustrated. All right,
I'll
we'll
take
be in
that one.
recess. I don't need any further enlightenment. Good morning. We're back. We're a little late. The parties all showed up late. Mr. James Bryan showed up late, and a representative for Connie Merriman showed up late. These matters were set for 9. I'll call them in here in just a moment. Grace, if you're listening, we've established that Mike doesn't know anything much about music. We had some time to kill while we're waiting for the defendants to show up, so we just had a chance to talk about things. All right, let's go on the record. We've got everybody, I guess, at least enough to get started. These are 2 zoning violation matters for a property out on Patterson Lane in Lockport Township. Defendant James Bryan, Bryan, is present in the courtroom. His file number is 252205. Connie Merriman is not present. Her file number is 2422040N. She called and said she was on the way here, but the roads were bad. They aren't that bad. And then she didn't appear, but then I was told that her son would be here, and apparently he is here. What's your name, sir? Charles Worthington? Is some of this stuff on this Patterson Lane property yours? Mr. David Zemansky is here for the plaintiff.
Your Honor, Trent Cunningham. I was with
sorry.
David last time.
I think I may have called him Trent one time. Trent Cunningham is here from, so tell him next time I see him, I'll call him Trent. Trent Cunningham is here on behalf of Lockport Township, as well as Dylan Aruda, also from the plaintiff's law firm. Also, Mike Hayden, zoning enforcement officer for Lockport Township. All right, let's go back to square one here. Let me pull these up. The defendants got cited for zoning violations for this property at 57901 Patterson Lane. The court is aware that Patterson Lane is a dead-end road that runs north and south from M60, I think, to the west of Three Rivers Airport. It's probably 3/4 of a mile long. It runs off the highway and dead ends, and we've had a number of zoning cases involving that short piece of township. The ticket the defendants got was issued on December 9th of 2024. It alleges that they are in violation of the building interim property maintenance code for multiple violations: recreational vehicles, RVs being occupied and or lived in, unlicensed and inoperable motor vehicles, RVs, junk, and other nuisance items stored on the property in violation of the township ordinance. And a number of pictures were attached, and this property, at least from the photographs, is as bad as anything I've seen in a while. So anyway, as I indicated, that citation was issued last February. The plaintiff has filed a hearing to show cause why the ordinance should not be enforced. Mr. Cunningham, what's the township's position here?
Thank you, Your Honor. The township's position is that an order was entered, as the court just noted, in June, pursuant to the defendant being found responsible or being defaulted, I believe, at an informal hearing. We submitted a compliance order, which this court entered back in June, which gave the defendant 30 days to clean up the property and to remove the items that Your Honor just noted, the RVs and the junk and the other nuisance items on the property. The township's position is that this has not been cleaned up despite the order being entered back in June, which led to the township filing its motion for contempt and leading to this show cause hearing. The township's position is that the property has not been cleaned up, and we don't see a path forward to get it cleaned up or to have voluntary compliance by the defendant's part to comply with the court's order. And so we're here seeking this court to enter a subsequent order that would allow the township to abate the property pursuant to this court's equitable authority in civil infraction cases, as I know this court is well aware. So the main thing we would want is equitable authority to abate the property pursuant to statute, then be allowed to charge a lien on the property if those costs of the cleanup go unpaid, as well as the fact that we're here on a motion for contempt, which statute authorizes the township to seek our attorney's fees and costs that we have to get us to this point and to have the show cause hearing and to appear here today. We would also ask that Mike's fees for prosecuting this violation related to the show cause hearing would also be reimbursed as well and charged to the property as a lien if the defendant is unable to pay that within a certain amount of time. We're here prepared to present testimony from Mr. Hayden to prove the conditions on the property if necessary, if the court would like to go that direction. But ultimately, we would ask for the relief, as I've just noted, and we'd be prepared to submit an order under the 7-day rule that would reflect that request. Happy to answer any questions that Your Honor may have.
All right, thank you. Mr. Bryan, we've been talking legalese, and Mr. Worthington, you got a ticket. Do you have some hearing difficulties?
A little bit.
Why don't we get him one of the assistance units? Yes?
I get paid tomorrow and I just looked up online about. Actually, after this court hearing is over, I was gonna give them a call because they opened at the same time as the court hearing.
All right, so you're connected to this case also?
Yeah.
What's your name?
Claudia Thompson. Claudia with a Y Thompson.
Your volume to go a little over higher. Okay.
I have the storage unit number saved and everything. That way I can call them.
All right, we'll get to that. Thank you. Can you hear now, Mr. Bryan?
Yes.
All right, good. These were upgrade we got with our recent Jazz upgrade, and they're very helpful for people. So I'm glad that we've got them to use. All right, you got a ticket. This property is in deplorable shape. And generally they work on this for months or more before they finally cite it. So last December, you got cited with this zoning violation. A hearing was set regarding that, an informal hearing, and you didn't show up for the hearing. So the township asked for what's called a compliance order. And I issued that last June as to you and to Miss Merriman. The compliance order, and I could read it line by line, but essentially it directs that this property shall be cleaned up Now, you were found responsible in February. They asked for the compliance order in June. Mr. Cunningham referred to two words that you may not know: equitable authority and abatement. Equitable authority gives, in certain circumstances, the district court the authority to order that things be done. Essentially, that the township come in and clean this up and give you the bill. That's what abatement is. They would clean it up. So I issued that order. I gave you 30 days from June 2nd to bring the property into compliance with the township and state zoning requirements, remove all unpermitted recreational vehicles from the property, no longer permit people to live in these units, and get all the junk off the property. Apparently that hasn't been accomplished. So the plaintiff has asked for this hearing. So, Mr. Bryan, I'm going to ask you if you'd raise your right hand. Mr. Hayden, would you raise yours? And Mr. Worthington, raise yours as well. Do you all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes. Yes.
All right, Mr. Bryan, as I indicated, Patterson Road has had its share of zoning violations up and down it, but this one appears to be particularly egregious. The other thing that concerns the court is when we have people living in these shanty things, and on a couple of occasions, someone has died when they caught fire and people were killed. There are a number of pictures which accompany the original ticket, which were taken back in 2024. The new case shows photographs that were taken by Mr. Hayden on December 3rd of 2025. Is that correct, Mr. Hayden?
Yes.
So you just went out the other day. I'll let you testify from there. So let's see if I can screen share these pictures. All right, we have on the screen some pictures, original and then more recent. So what are we seeing here in the first photograph? It says it was taken on December 9th of 2024.
That is a picture taken from the road showing the campers in the back. And you can see some of the junk over to the right side of the photo there.
You can see the tops of the camper over that makeshift fence.
Yes, there's one there, and then there's one to the right of that bush or tree or whatever it is there. That is more of a close-up of the campers and the drive going back to them. There's junk off to the left there.
Now, is this a residence, the dwelling to the left?
Correct.
Does
The house
somebody,
is up front, and there's two campers, at least two campers in the back.
all right, does somebody live in the house?
Yes, I believe that's where James and Connie live.
Okay.
That's just showing the fence and the items on the left there, and then the drive going back to it.
Well, it was a lot different last December 9th than it will be this year, I think. It's still green there. Now, you show here, they've been driving on the neighbor's property. So this shows this poles with these ribbons on it is where the property line is.
That's my understanding. I don't know for sure.
This
That's
looks like
just the citation posted up front.
that fence was new once.
That's just some items that were piled in front of the house.
So in addition to the back, there's a bunch of stuff in the front.
There was, yes.
As I said, these aren't even the worst of them. Now we'll go to the new set of pictures. All right, this is the set of pictures that you took just this week. Is that correct?
Yes.
All right, now, first of all, I guess we should establish, I sort of jumped Mr. Cunningham's claim here and just took over, but do you swear that these pictures are true and accurate representations of what you saw both in December of 2024 and recently here in December of 2025?
Yes, I do.
All right, so you went out just within the last few days and took these pictures.
Yes.
All right, what are we seeing here in this first picture?
There are some tires piled up, lawnmowers. Some of them are just parts. There's vehicles there that have been sitting for quite some time, and other items just that's coming down the lane. I walked down it because it was not navigable by vehicle. Some more of the items off to the left there, tires and other stuff. And then there's one of the campers behind the pickup truck. That is items that are piled up and accumulated there behind the house. There's some type of fence. I don't know if it's for dogs or whatever, but there's again, lawnmowers and some other things that are behind it. That's one of the campers that's being used for storage and or being lived in. And then there's some pallets along the fence there.
So you couldn't tell whether someone's actually residing in there?
In a later picture, there is a porch light on that, on one of them. That's from the back side of that camper, showing there's a generator that was being used in the past, but it's now, it appears that they've run a cord up to the house, and that's shown in a later picture. And some more of the items, tires. That's just a close-up of the items that were piled there, accumulated in the back. That is another area of tires and items accumulated over on the back side of the property. There's two campers there that are shown. One of them, the one on the left, you can kind of see that the porch light is on. Between the two campers, it's shown more clear in another picture, but that's just another angle of the items in the campers. Neither one appeared to be licensed. And then that's a close-up showing the light on. Another angle of the backyard that's next to the campers. I believe the trailer had a plate on it, but the other items would be violations in the vehicle in the background.
This truck back here that we're seeing that's covered with snow, that's currently not plated?
To my knowledge, it's not plated, yes. I did not walk that far up on the property. That's just the driveway they're using that's in the backyard. I could not clearly see if that one had a valid plate on it because it's covered with snow. That's just another shot of the items that are up behind the house.
There's a lot of unoperable lawnmowers around there.
That is apparently a couple of couches and chairs that are sitting in the front of the house.
Well, most people do that. So that's the condition of the property in the last few days.
Yes, as of yesterday.
All right, I'm going to go back to some of the original photographs.
Your Honor, there was also photographs that we submitted, and I have physical copies here that were taken in September of 2025, and those ones don't have all the snow, so they're a bit cleaner.
Yeah, I'm going to go back to those where you can see.
When I wrote the citation, I took everything from the roadway because I felt I had enough to get the citation issued. The compliance order allowed me to go on the property for inspection, so I took a deputy with me on September 4th, and that's the pictures that he's referring to.
Those were exhibit 1 at the informal hearing. And they accompanied the order in June. So we can perhaps get a better view of things without snow over everything. But essentially, exhibit 2. This would be what the property appeared. Oh, I don't have this in here yet. Let me stop the screen share. Restart the screen share. All right, is this what the property appeared to look like in September of 2025?
Yes, September 4th.
Which was after the compliance order was issued in June of 25.
Correct. That's when I sent the photos to the attorney to request a show cause.
All right, what are we seeing here?
That is a vehicle that is parked in the back. I do not know if it was licensed or not, but there's also some other items and stuff piled up there to the left. I don't believe that. I don't remember if that vehicle was still there yesterday.
All right, here's a better unsnowed view of the trailers. What are we seeing here?
That is the 2 campers. One of them is being lived in, and I believe I was told by one of the Mr. James, that the other one they were just using for storage, but I did not go in either camper to verify that.
There are 2 actual gas power generators.
Yes.
In the forefront of that picture.
Yes, and several gas cans.
There's a fire hazard. What is this tent structure off to the right?
That's one of those park garages, I call them, where you just put them over the vehicles or whatever. You can store stuff under them as a temporary solution.
And we have a guitar amplifier.
Yeah, there's an old filing cabinet, which was still there yesterday.
Here we got just, I'm not even sure what I'm looking at. What is this?
That is, again, there's the trailer on the right, the car trailer. The other items there, it's buckets. They're full of, I don't know what. And then there's also an accumulation there of the items, just general garbage, and as I refer to them in the ticket as nuisance items that just don't belong to the backyard.
What is this? A freezer that's on its side?
It appears it could be. In the photo I have here, it's tied shut. You can kind of see the cord there in the middle. I don't know, it's some kind of a container. Maybe it looks blue in my photo here, so it might be just some sort of I don't know honestly what it is.
It's my box. It's on his trailer, though.
Okay. What is this? Some other shots of the dysfunctional
Yes.
trailers?
Yep. And then another shot of the propane tank and some other things that are sitting.
There's a dog there. He looks like he's interested.
Yes. That's just a little closer towards the house so that you can see both trailers and the items that are piled in front of the trailer, the rounded trailer there.
This looks like something from the Dust Bowl era from Grapes of Wrath.
Several tires and buckets, and there's containers. There are tools there. Look for maybe working on a vehicle. which would be in themselves okay, but the other items that are accumulated around it would not be.
There are actually 2 dogs, it looks like.
This is just a close-up of the generators and the cords showing them that they are running to the campers on that day. They were not running when I was there, but I'm not sure if anybody was in them at the time. But yesterday they obviously were not running, and there is a cord running to the house, which I failed to point out when you had those pictures up. And then again, just the gas cans and items around the back of the camper, the generators.
All right, so that's photographs from last December,
September 4th.
last September, and this December. So I'm gonna admit all the photographs from all 3 sessions for evidence in this hearing. All right, I'll stop the live share. We'll go back to our screen. Mr. Bryan, who lives in the house?
Me and Connie.
And who lives in the back?
It's Connie's son and his girlfriend.
Always, I shouldn't be anymore surprised at how people can live and saddened. But I see this all the time, every month, just accumulated junk. This is several issues. There's sanitation issues, there's fire safety issues, there's electrical issues, there's all this other stuff. So you got a ticket, Mr. Bryan, last December. They had a show cause hearing, or they had a hearing in February that you didn't show up for. You got served with the compliance order in June, which apparently very little's been done to clean it up. And then they were out there again September to take other pictures. So their patience is wearing thin. What's your position here?
Well, in 2023, or June of 23, went from Judge Hostetler, gave me 2 PPOs I had put against her son and his girlfriend, and the sheriff come out and told me to stay up there at the house, that Connie owned half the property and she gave him permission to be out there. And
Who's Judge Hostetler?
our, well, from here.
Well, let me see what you got. You had some stuff in your pocket. Do you have the PPOs?
Yeah, that's
All right. Claudia Thompson. You got a PPO against Claudia Thompson, issued by Judge Stutzman in 2023. And it's often difficult to do a PPO when the people are on the same property. This was by Judge Stutzman. And then you have a PPO against Charles Worthington. These are expired. They're not currently valid.
that's just so I show that, you know, they.
All right, so you got a PPO against them, correct? All right, so is all this junk in the back belong to Charles Worthington? So you got a PPO against them. They live in the back. Are you and Connie married?
No,
Do you jointly own the property?
yes,
All right, so she has a half joint own tenancy with you.
I was a co-signer for the property, so it's I'm considered third party. You got Connie and then the mortgage company and then me.
All right. So, all right. Do they pay any rent?
No,
All right, Mr. Worthington, why don't you come up to the podium? Come right up here if you would, when you're under oath. Good morning, sir. Are you Charles Worthington?
Yes.
The township is taking expensive legal action to get all your stuff off this lot. What's your position?
We just got back to, or my fiance got back to work. We're trying to get stuff caught up and get the storage unit so we can get stuff out of there. And I've been cleaning it up,
All right, well, it doesn't have to happen as soon as tomorrow, but what are you gonna do with these trailers?
getting storage units for them.
This storage unit has outside, storage and, facilities that can store.
All right. All right, thank you. You can have a seat. All right, so Mr. Worthington is apparently the occupant of this site, along with Miss Thompson. I can't believe someone would live there, but they apparently do. And they are willing to begin removing their property. They don't own the property. You and Miss Merriman do, and she's not here, so she's gonna get defaulted. But the person that's gonna get the bill for this is you and Connie Merriman. And the bill is gonna be tens of thousands of dollars. Unless they remove the property from there. They're gonna have to hire a company. They're gonna come in there. They're gonna load up all that stuff into dumpsters and take it to the dump. They're going to hire a company to tow off everything there that is not licensed and take it to the dump. And they're gonna give you a great big bill and apply it as a lien on your property. The township has been very patient. They worked for a long time before December of 24. They had a hearing in February of 24. We had a compliance order in February of 25, compliance order in June of 25. And you guys have responded to this by essentially ignoring it. One problem we always run into at this time of year, Mr. Cunningham, is we're covered with snow. The ground isn't quite frozen. It's going to be muddy, difficult to get that stuff out of there. So that's always problematic. And it's always to the township's benefit if the parties get the stuff out of there themselves, rather than having you hire a company to come in and do it. How much time are you willing to give them to remove the property?
Your Honor, I think practically speaking, it's going to be until spring before the township could get a contractor to go out there. So I think the court's well aware at this point, it's been a long time. And so we would ask to be authorized to remove the property immediately. But I think for practical purposes, it would be probably at least a month or two, maybe March, I would say is a reasonable timeline. Whatever the court would like to do in that regard. But we would ask to be authorized at least immediately, given that it's been so long since the compliance order came out.
And that's what I'm, and as I said, we run into this every year in December and January, and they've neglected it. But one problem is someone's living in there, and that's immediately going to be prohibited. They're going to have till March 30th to remove the property, or the township is authorized to remove the property and bring the property into compliance.
Your Honor,
Yes?
They have done quite a bit of getting stuff out of there. And also, I believe we got the property and house sold, and the closing on that is supposed to be first part of January.
Okay. Who's the purchaser?
I don't have my phone with me, but they're out of Florida. One of those, that buy
We'll
as
buy your
is.
house? Okay, well, maybe that's a way to resolve this. In the meantime, you can't live in a trailer parked out behind somebody's house with a cord hooked up to the house. Someone's gonna die out there.
I'm currently working with Neighborhood Inc. because they had to fire everybody that was there. They apparently weren't doing their jobs. They got all the people from there. And that's right here in Centerville.
Okay, well, I'm glad they're back in Centerville. I had not heard. Maybe I'll contact them. All right, but Mr. Cunningham, that complicates things. Certainly, this often fixes it. A bank repossesses the property and they clean it up. Someone purchases it, maybe a neighbor purchases it because they're tired of looking at it. They clean it up. I'm going to give in the order, the plaintiffs have the right to enforcement. Defendants and their successors shall have until March 30th, 2026 to clean this property up. So if someone buys this property from you in January, the township won't take any action until March 30th. But you got stuff in the front yard, stuff in the backyard. The occupants of the trailer have 10 days to vacate or they will be in contempt. In which case I would do an order ordering the sheriff to come evict them from that property. That's dangerous. It's not sanitary. It is an electrical hazard and it's dangerous. And you can't do it anyway. So you have 10 days to get a place to go or take that. Is it a motorhome or a trailer? It has an engine in it? Trailer, okay. You don't have to move it within 10 days, but you have to be out of it within 10 days or I'm gonna find you in contempt. Mr. Cunningham or Mr. Aruda, anything else you wish to add to the order?
Your Honor, if we could just clarify the issue of attorney's fees.
Yes.
In the past, when we've done this, we've just submitted a bill of costs with both our fees and Mike's fees along with that 7-day order.
The statute does allow for that. There is gonna be an order for money for their attorney fees. The township is spending thousands of dollars for this enforcement. And this started out small and grew into what it is. Why people store junk tires? Because it costs money to get rid of them. Twice a year, you can dispose of them at the county disposal day for $2 a tire, but there's probably 100 or more tires on there. All kinds of other stuff. Some of it has value, the generators or boats and some of it's just plain junk that needs to go to the dump, and some of it may be scrap that has some monetary value. But I'm sure that whoever's buying this property doesn't wish to buy it to have a junk heap on it. I think they're going to turn it into a house like it once was. And as I said, they're attempting to clean up all of Patterson Lane and all of Lockport Township, one parcel at a time. This would be a default as to Miss Merriman because she did not appear. But it's the same order that would apply to Mr. Bryant. So, Mr. Bryan, your plan is you and Connie plan to move out of the house sometime before January?
That's the idea.
And then the new purchaser will have it. And in the meantime, Mr. Worthington and Ms. Thompson are gonna try to clean the back up. That personal protection order is no longer in effect.
Right.
But so is it
No,
stand,
I just,
but so you stay away from each other? You stay in the house and they stay in the back?
yeah, basically.
Well, it's your property and Connie's, and you can't let people do it. Your neighbors are complaining. The township's complaining. People complain to the township. Like, how could, in fact, as I'm looking at it, I'm thought, how could this exist? How come it took this long? But I often feel that way when we get into these situations. They don't happen overnight. All right, do you have any questions?
No,
All right, they're gonna do an order after this hearing where I find that you are violated my compliance order by doing nothing. Miss Merriman isn't here. She lied to the court when she said the roads were bad and she was late. She just wasn't coming. So her son has come, but he's a source of much of the problem. So it's good that he's here.
she is sick.
Okay, well, she didn't tell me that. She told me she was on the way here.
I'm the one who called. I said that her son was representing her. I let him know up there that she was not feeling good.
Okay, maybe I misunderstood. At any rate, you guys got work to do. Anything you want to get out of there that you don't want destroyed, junked, you need to get out of there. So if you've got a storage space and you're gonna pull all this stuff out of there, you got sooner rather than later, because the property's gonna change hands in January. There's also gonna be an assessed cost for attorney fees and the inspection and enforcement fees. And you won't like that much, but it will be attached to the order with what's called a bill of costs. And you and Connie are jointly responsible for that. Maybe you can use the proceeds of the sale of the house to pay those fees.
Your Honor, if I could just clarify the order, then if they do go unpaid, either the attorney's fees or the cleanup costs, if we get to that point, would we be authorized to impose them as a lien? I know the statute
Correct.
provides for
That's
that, but just to make sure it's clear. Thank you.
All right, anything further? All right, Mr. Bryan, do you know where you're moving to?
No, not right offhand. So say my brother's got a place in Florida. I thought about.
Yeah, I didn't know if you were gonna move out of state, if you're gonna stay here in Michigan.
I have no idea right now.
Well, there's not a lot of time between now and then.
Well, till I get some cash from the house there, and my understanding is me and Connie will be splitting up. So she'll take her half of the money and.
All right, well, maybe that's for the best. They'll get the junk off the property, someone will buy it, somebody will turn it into a habitable house. Township will be happy and you guys can start fresh somewhere else. All right, this record is completed. I'll await the order under the 7-day rule. And you guys are all good to go. Mr. Worthington, you got your work cut out for you, but let's hope the weather breaks a little bit. All right, thank you.
Thank you, Your Honor.
Town Center Place versus Melvin. All three cases, is that or two cases? Three cases.
Good afternoon, Your Honor.
Yes, good afternoon.
What do you think?
Yes. Okay, state your appearance, please. And Miss Melvin, can you hear me?
Yes, I can.
All right, state your name for me.
Second Margaret Melvin.
Thank you. Okay, I'm almost afraid to ask, but where are we?
We're having some issues, Your Honor.
Pardon?
We are having some issues, Your Honor.
Okay, what are the issues?
We have a few, I believe it was three occasions? Two occasions in which we pulled the fire alarm for not having heat in our unit.
Okay,
We also have a note on the door that we're not permitted entry for insect control or pest services, which was a important point in this case to continue that. And then we went in for to assess the heat as she was concerned about it, and the unit is reading 85 degrees. So there's
I'm sorry.
the unit is reading 85 degrees. There's no heat issue. So the fire alarm pulls were not only unwarranted for a fire, but also the concern in which she complained about wasn't present.
Is that it?
That's what I have at this moment.
Okay,
But,
all right. Okay, go ahead.
One of the.
State your name, state your
My
name.
name is Michael Melvin, I'm Sandra's son.
Okay.
She did pull the fire alarm on an occasion, she was in the bathroom, turned on the fan caught on fire, it was blowing out smoke and flames.
Okay. Did you report that then to the landlord?
They know about it.
Okay, and so that was on one occasion, my understanding.
It was like 3 months ago. There was an electrical fire. And about 4 days or 4 weeks later, there was another electrical fire in the building on apartment 508. Okay, this turn.
Okay, so and council, what were the dates?
I'm talking about 11/27, correct? 11/27 on two occasions that day.
Okay, so both happened on 11/27, so
I'm sorry.
that's,
One on 11/27.
Hold on, I can find it.
And then 11/18.
okay, so 11/18 and 11/20.
Wait, I'm sorry.
One on the 18th and one on the 27th.
Yes.
11/18 and 11/27.
Yes, John.
Okay.
And I have proofs if you'd like to see.
That what?
I have some proofs if you'd like to see.
Well,
I'm offering, you don't have to take it, Your Honor.
no, I know, but I guess what I'm trying to figure out is when the bathroom fan did whatever it did, that was not one of these 2 dates.
No, no.
Okay, so then I'm gonna ask this. Why'd you pull the fire alarm on the 18th and 27th?
Well, when I turned on the heat in the unit, it went poof. And had my experience with the bathroom, I pulled the fire alarm because it's right outside my door.
Okay, so
But I expected to think go into a flame, and I didn't want it to get any bigger.
okay, let me ask this.
So with the
Hang on, are these gas furnaces?
No, they're boiler system, I'm sorry. Boiler system, but there is an electrical fan in the system.
Got it, okay. But there isn't a flame of any type. All right, but you heard a sound. Right, and so because of that and the experience that you had with the bathroom, you pulled the fire alarm.
Yeah.
Okay, so let me ask you this. Did that occur on both occasions?
Yes.
So on both of the times you pulled the fire alarm, you did that because you heard that sound?
Well, they didn't come and didn't make it operating, so I have heat coming out of the heating unit. it didn't work. A little bit of, on the top of the filter was a little bit heat, but the whole unit didn't keep my apartment, it didn't keep it warm. They called in some expert, I guess, a little kid, and he looked at it and says, oh, no, it's fine.
Okay, but
I
But when
didn't
they-
get any heat.
okay, but when they went to your unit regarding the heat, they said your unit was at 85.
Well, was it a sunny day or was it a cloudy day?
Can I add?
Sure.
Okay. I know I did come, one day I did come out there. Renee told me that she put the fire alarm because of her furnace. Her furnace hasn't worked, the fan hasn't worked since October. I'm assuming the noise she heard are the capacitor for the fan to start. When I went up there, when they were doing the countertops, she set up on the maintenance man, so younger black fellow, real nice fellow. He come out there, he went over, he flipped it to low, he flipped it to high a couple of times. He said it definitely wasn't working. And his first protocol was to go get a new thermostat and try the thermostat before they called anybody.
Got it.
Please been back since then.
So the unit, are you saying that there is not heat in the unit now?
If you put your hands on the wall, it does not go out, the fans do not come out. There's a thermostat, like she said, there's a fan blower in the wall.
Right.
Yeah. There's a switch to turn that fan on or off, that is not working.
Okay, so the switch to turn the fan on is not working.
The thermostat,
You guys know anything about that? I mean, the thermostat's gonna do a couple of things. It's gonna, but, okay. Yeah.
Our units, it's heat or hot.
Understand that. Because like I say, if you go.
Yeah, but here's the thing. What floor are you on?
Right.
Okay. So some of the heat that she's gonna receive are gonna be from other units. And so my only question would be, is her blower working?
According to our expert, yes.
Expert who?
Monroe Plumbing Heating Company. That
When did they go out?
They were there on 11/18. They sent us an invoice. It says the heating system was functioning properly at the time of assessment.
Okay.
There, the maintenance man was there, he said it wasn't working.
When was that? When the maintenance man?
Counters.
That was prior to.
That was prior to that point. But on the 18th, somebody came out and said it's operating. Okay.
That is the note that I
I
have.
was there, turned it on, turned it up on high, fell all the way up, nothing. Flipped it over to cool. turned it
Okay, but let's put it this way. They have somebody that less than a month ago was saying that the heating's working. I'm going to assume that the heating is working unless I see something else. I'm also going to indicate that if, even if the heat is not working, and Ms. Melman, it's not an appropriate response to pull the fire alarm.
He said he could not pull the fire alarm for those reasons.
Well, I don't understand that, but you said experience in the bathroom.
No, okay.
No, that's in my mind.
Okay, but here's the problem with that, Ms. Melman, is that when you do something like that, and it's not a true emergency where there is indeed a fire or a threat of fire or a threat to somebody's life, then what ends up happening is you're pulling resources away from other activities or duties that the fire department needs to deal with.
I understand that, but I'm not that knowledgeable about heat and this and the fire department, all that. I'm 83 years old. I'm supposed to be nice and safe and warm at home.
Okay, I understand that, but you can't be pulling the fire alarm unless.
I will not do it the next time, sir.
Okay, very good. Okay, so now there's the issue of insect control. Why'd you say they couldn't come in the unit? Why'd you put a sign up?
Well, remember the first day in court I came and I brought the sack was 22 pounds of mouse poop?
Hey,
Well,
how am I to forget?
the exterminator doesn't come and pick up the dead mice. So I have to do that. And I take it down to the office and ask him what to do with it. Then the exterminator come, he will put the box down, but he didn't bring any traps. Like today he came, and the last time he came was like September, and they posted this note on the door yesterday that pest control is coming tomorrow and there will be between 9, and it is mandatory. Mandatory means I have to be out of the apartment with my pets for at least 4 hours. Clear off all your kitchen counters and items stored under the kitchen. Clear off the top of the refrigerator so the tech can pull it out. Which is what I did, that's why I got all the mice poop. Remove all your sheets, covers, dust ruffles, comforters, pillows, and other bedding covers from your mattress and box spring, including protective bed bug cover. If not removed, the technician will remove them. Tenant must stay out of the bedroom treated area for a minimum of 4 hours. Remove all personal items from furniture, couch, chair for bed bug inspection only. If you have any question, you notify them. Well, with all this remodeling and removing stuff out of my apartment, the whole thing is a big mess. It's gonna take me about 6 months to be able to find stuff in my apartment. And this eviction proves that the mice not there, because I haven't seen any mice in 2 weeks. And they don't come up and inspect mice or come and pick them up. But I go down there.
All right, but Ms. Melvin, here's the thing. The unit has to be treated for insects. Okay?
No?
It has to be treated. So you have to cooperate in that treatment. And the way that, hang on, the way that that's going to happen is they are providing you what they need you to do so that the treatment can happen. Okay? So what you were reading to me was a pretty standard letter that tenants or notification that tenants get at all the complexes that I think I hear. I could almost mount that list before you, as you were saying it. That's what has to be done to prepare the unit so that it can be treated.
Well, it was done 4 months earlier when they came in and put up all the noses, all the stuff there. And I had to pick up all the dead mouse even off the balcony. So I went through all that treatment.
But you can't just treat once and that's it. It's a periodic kind of treatment that they have to do to make sure that there aren't these insects in the apartment. Okay? So that it's gonna happen more than once. And one of the reasons why they give you that notice of that list is so that you're aware what you need to do so that when the treatment people come, they can just get their job done. You're out of your unit and they can move on and do what else they need to do.
Yeah, but all that stuff out of the kitchen, all the bedroom,
But-
all that stuff is all over the place. Plus, where you're supposed to put it, if you take it off the stove, take it off here, take it over there. We're old people, we're seniors.
I
I've
know.
been there, so, since 2006, and we never had this kind of a treatment.
Okay, but that's a pretty standard treatment. Okay, if they weren't treating that way before, I'm not sure why they weren't, but that's a pretty standard treatment. All right, and the problem is, Ms. Melvin, is that if they aren't able to treat in that fashion, you actually end up in a situation where they may have to treat the place more frequently, because if everybody doesn't cooperate in that process.
But they just did my apartment for 3 months. They're coming and this, and they come in and they didn't even bring the mouse traps, and then they bring this and that. I just went through it for 3 months.
Yes.
As she did have an issue, she's gonna be having it for a while.
Pardon?
As she did have an issue with mice, she's gonna be having treatment for a while.
Correct.
So that they don't come back.
Right.
It's-
Don't come back.
The mice and any other insects that got in where the mice got in, yes. It's a long process and it is bothersome, we understand, but it's gonna be every 2 weeks for a while because she did have an issue.
I've been doing this for 3 months.
Okay, but
And like the guy doesn't even come in. Matter of fact,
so
he
the
hasn't been coming for the last 4 weeks.
so the current treatment plan is every 2 weeks.
Every 2 weeks, yes, Your Honor.
Okay, so when is the next treatment scheduled?
It was supposed to be today
And it didn't happen.
and it didn't happen because she put a sign on her door saying that she denies entry. So then it's gonna be in another 2-ish weeks, probably right.
No, that's not what the whole note said. The whole note said, I
have a
need
picture here.
new poison boxes and new, the mouth trap. So I put them in the bag and I talked to him and he's gonna bring me new ones. So I'm already following instruction. So he takes the
Okay.
old ones out.
Okay, but here's the thing. Ms. Melvin. And I don't want to have to do this because it won't necessarily do anybody any good. But you're going to need to let them into your unit every 2 weeks.
No problem there. But right now, because they moved all my stuff out of my house, I got boxes here, boxes here, boxes here. I don't even know what box has what. So he's gonna come in and probably fall over the boxes. Because I had to clear everything off my balcony because of 5 plants. My whole balcony is empty now. Who's gonna reimburse me all that money that went out the door?
Okay, that I don't know the answer to.
Oh, okay.
All I know.
No, but all the stuff that was removed, there weren't any dead mice in the boxes that were removed. So I got stuff over here, and then they say probably come in, oh, it's not 32 inches from that. Well, 32 inches from that was created by the other manager. When she decided to move my bookcase to that side.
I recall this.
The bookcase over here, then put the couch next to the bookcase, so all of a sudden the space from here to the window ain't 32 inches.
Your Honor, that's
You know, they come and they expect to do the
Standard,
job.
that's not
No, we're covered by her. We're supposed to be safe seniors living.
Okay, hold on a moment.
That's a city standard, that's not,
I know.
we have to follow the.
The
city
32
standards. We
inches.
can't-
Yeah, okay.
we can't budge on that, Your Honor.
What's the 32
Well-
inches for?
It's basically gonna be a hallway between thing. So it's about a 32 inches, that's their minimum hallway.
Oh, well, I fixed it.
What's the problem with hers?
I think she doesn't have pathways that are 32 inches, or there's 32 inches from some item. So for example, if you had a furnace, you need to have, things can't be closer, I think, than 32 inches to that furnace.
Why don't,
Other ingresses and egresses. So,
And it's
The hallway there,
36.
pardon?
It's 36 inches. You're right.
Yeah, I was gonna say, when I was hearing 32, I thought it was 3 feet.
Yeah, it's 36. It was adopted by the city. It's a city, and Your Honor, as she stated before, she's the one that called the city out to inspect her unit. The city found this, not us.
what?
found what?
Huh?
Found what?
That
Okay.
she was failing to provide a minimum of 36 inches throughout the unit to every window by the code that was adopted by the city. The city building inspector decided that, not us.
Okay.
And we have to follow what the building inspector says.
I have pictures, recent pictures of the apartment.
Okay, well,
Copies.
yeah, no, I get that, but
Are you saying her table's too close to her couch?
Oh, I'm not saying that. We haven't been able to go in and inspect as she denied us entry for the pest situation. So I'm not saying that. I'm saying she was saying 32 inches and acting or presenting it like it was the previous manager. And I was just clarifying that it wasn't our management at all. It was in fact the city building code, which we are,
the city building code requires that there be certain clearances. And it's typically 3 feet.
Clearance to the approval of the previous manager.
Pardon?
That was completed to the approval of the previous.
Correct, but here's the thing, that while there may be these periodic inspections, those clearances have to exist at all times.
Okay.
So it's an issue. I mean, quite frankly, the way that this works is, and you realize this happens in places, is the inspection happens, they clear it to 36, and then quite frankly, just the reality of tenants, they will move that stuff back. And I mean, but when the inspection happens, the clearance needs to be there.
No. When you move in, HUD gives you a sheet, which I find that it tells you, you want to be happy, enjoy this, enjoy this, enjoy this. Then all of a sudden, what now comes up? You have to be this way and this way. Well, why don't they give you that blueprint when you move in?
Okay,
you know where to put your
okay,
furniture.
but Miss, I can't go back to the time that you moved in,
I know.
all right? So what I've got to do is I've got to deal with what we have right now. All right? But in terms of the approximate 3 feet, right now, my understanding is the inspection hasn't happened. So I'm not sure it's right for me to deal with even at this point, because I don't know that you're necessarily in violation of that. So I'm not going to deal with it. So I just need I need you to allow the insect treatment.
Allow what?
The treatment for pest control treatment. I need
Yeah,
you.
that's no problem, because I told them if I to put the box.
Yeah, but you can't, but Miss Melvin, if they're going to come today, you can't then put a sign saying you can't come in today.
Well, I left the bag with all the dirt stuff in there on the front door. And I talked to the fellow and I said, I need new protection, the poison box, and I need new mouse traps. So he says you bring it.
They still need to treat for the bugs.
Hmm?
They still need to treat for the bugs.
Well, I don't have any bugs.
I know you don't. That's besides.
I've been there over 16 years and I had any bugs.
Well, and they're trying to make sure that you don't, they're trying to make sure that you don't end up with any.
Pardon me?
They're trying to make sure that you don't end up with any. Sometimes, Miss Melvin, it's not necessarily you. It could be another unit, it could be whatever, but you've got to comply in the treatment, okay?
And,
Okay, no problem.
and Your Honor, once there's a presence of like mice or other things, there's a way that they're getting in. Which
Correct.
prevents an opportunity for other insects, other things to get in through the same way that the mice got in.
Okay,
Why'd you?
the mice come
See,
through
here-
the wall.
I
And the
know.
mice can also come through the walls, is the point.
On the third floor too.
Yeah, but they can crawl.
I don't know.
They can
Mice.
crawl, that's the point, they have to.
It might be the flying mice. I don't know, but look, people. I just,
Some of the mice come through the walls. I bought tape to keep it sealed so they don't come out. I spent about $40 at the hardware store sealing them up so they come up because the treatment doesn't do that.
so here's what I'm doing.
I even picked up mice at the whole city hall.
So here's what we're gonna do, Ms. Melvin. Okay? There's the next inspection or treatment would be the 19th, and then there would be one, is it gonna be January 2nd then?
There's a nest
I would
infection.
say,
Where?
wait a minute. Let me look at the phones, or the calendar, sorry.
Who is? Oh, she is. Okay. I didn't see. Miss Young?
Yes.
Miss Young, you have your hand raised. I see you now in Zoom. My staff let me know. I wasn't monitoring my screen.
Okay, are you able to hear me?
Yes, we are, ma'am.
Okay.
How are you?
I'm good, thank you, Your Honor. Yes, I do have a question
Sure.
in regards to Adult Protective Services and our involvement with Miss Melvin. It came to our attention because she was at risk of being evicted. We've been working with Miss Melvin since August, August 28th to be exact. I've been to her apartment several times. I've spoken with her. I've spoken with management. She also has resources through the Housing Bureau for Seniors. Adult Protective Services is not servicing Miss Melvin at this point. The service that we were attempting to provide to Miss Melvin was provided to her by her son. Her investigation is still open with us. My question is, I can't close out this investigation until I know that Miss Melvin is no longer at risk for eviction. So she's kind of just, we've been kind of just sitting in the corner waiting to find out the outcome.
Yeah.
It doesn't seem like an outcome is going to happen anytime soon. Is Miss Melvin at risk for eviction? And at this point, is this just an issue? You know, it just sounds like it's not APS worthy at this point. I'm not sure
Yeah.
what we're doing here.
Well,
will Ms.
let me, can I stop you for a moment and let
Yes,
me just
yes.
explain part of that? Hey, I hear you because you also have to understand that for me, I started with one case involving a condition on her balcony. And so that was the original case. Subsequent to that, then another case was filed before we finished the balcony case. And another case was filed involving other issues which could lead to her termination. And I think that one,
Termination and then the health hazard.
the health hazard.
What was the health?
Hold on. I'm just trying to explain why we're like almost, well, we're not a year down the road, but we're a ways down the road. So maybe, certainly from any outside agency attempting to try to assist somebody, I think for you, you're looking at it like this thing started at this point, and now we're way down here, and it looks like it's not going anywhere. And that's because there are different targets. So then when we were dealing, and also appreciate this. So then when we were dealing with the health and safety issues, other issues regarding the balcony came back up. So I couldn't even close that case. And so it's just that we have these 3 cases all kind of filed at different times that just extend it and place her at a risk for eviction. Does that make any sense to you?
Yeah, it does. But from a APS standpoint, is she is she safe? Is she vulnerable? It's just growing into something so much bigger. From an APS standpoint, she appears to be safe. She's not vulnerable from our perspective. This seems like a landlord tenant issue.
Yeah, no, I think so that's probably a good point. I would have to say, if I'm looking at it from that standard, I would think that she is not vulnerable at this moment to eviction. I would attribute that in great part because of her son coming along and certain assistance being provided to get things done. All right. Now, in saying that, I'm not predicting the ultimate outcome of the cases, but I get what you're saying. I mean, you're trying to deal with seniors that are at risk, serious risk of eviction, and other sort of bad things occurring to them in their housing. And
this just doesn't feel
I
like
would say this. At this point, as long as her son, as long as progress can be made, I would place her into a different category than that of vulnerable. Does that help you without me bringing a ruling?
Yes, it does. Yes, it does. And I will consult with my superiors as well, because this is a investigation that is not an investigation any longer. It's just kind of waiting on an outcome.
And I get it, because frankly, even as a case itself, it's not a case that it's not my typical case. It's just I get these layers added on, and it's trying to sort of manage a circumstance here. So I hear you. All right.
Okay.
All right.
I understand, Your Honor.
Okay. So go ahead, ma'am. What were you gonna?
I will consult with my superiors to see if it's necessary for me to continue participating in these hearings, and also if we can move forward with an investigation closure, as it doesn't seem that Miss Melvin is at any type of imminent risk for harm.
I would have to agree with that. And the main, it's just, it's like every time I'm getting here, there's something else, but it's not.
And we were going to talk conditional dismissal today.
What'd you say?
We wanted to talk conditional dismissal today. We wanted to talk terms to put in a conditional dismissal to finish.
Right. So.
She was no longer.
Right.
That is where we are. However, we just kind of keep having these
Correct.
things that pop up that we have to deal with and we can't ignore. And while we're in court, it's like.
Right. So, ma'am, I don't know if you've heard that or not, but what everybody is looking for is a conditional dismissal with certain things laid out. If I were still on the first case, I could lay out myself the specific things that needed to be done. However, it moves. And so we've got to sit down and try to figure it out once we can get things sort of stabilized and put together a conditional dismissal.
Right.
So and that's where I'd like to head. But every time I get here, we've got to kind of head down some other path.
Yep.
And I'm going to let you know so you can have the opportunity to certainly speak with your superiors about closing the case. And while I appreciate why you might have to do that, it has been a comfort to me that you have been here. So, and I do really mean that, because it's one of those things of just, as we're trying to sort it through, you hear different things where there might be certain things that may be needed than the court would. So, you know, so that's where we are.
Okay.
And folks, here's what I'm intending on doing is I want to get through two of these,
The
pest inspections. And then I want to set this for a final settlement conference so I can hopefully close my 3 cases
Right.
with a conditional order of dismissal.
So, Your Honor, we do believe that it's the second if the pest control services are open that day. If they're not, it would be the 9th. The
9th?
That they would come.
Okay. So what's
So
my
that-
date after the 9th?
Tuesday the 16th.
16th. Okay, so here's what I'm going to do.
Tuesday the 16th.
Yes, Tuesday the 16th at 9 a.m. I'm going to
The
watch.
13th, you mean?
Are we talking December or January?
I'm talking January.
I apologize,
I was like, that's a Friday.
Thank you, Ann.
Can I help you?
So what would it?
The first date after the 9th, which would be a Tuesday in January, is the 20th.
The 20th. All right.
Okay.
So what I'm going to do is I'm going to set this for January 20th. All right. So on that day, rather than have these numerous hearings going through saying we're going to do X, I'm going to order at this time, Ms. Melvin, that you're to comply with all pest extermination services and inspections.
Okay, can you say that again? Because I'm totally.
When they are coming to spray for bugs, all right, and
Okay.
insects, you are to cooperate in that process.
Call what?
You are to cooperate with that process.
Okay.
Okay, I don't want any more notes on the door that they can't come in.
That's the first time I put a note.
I know, it's the first time and it's gonna be the last.
And I didn't say he couldn't come in. When he brings me the new stuff, he could come in and post it.
Okay, all right.
It's a whole note.
So then, here's what we're gonna do on the 20th. Because I have the same feeling as Miss Young. At some point, this has to end.
And Your Honor, we believe that by that point, the city will be able to reinspect as well.
And the city will be able to reinspect.
Right,
So
that should give us enough time.
what I'm hoping is, at that point, Ms. Mellon, just listen to me. At that point, I'm gonna take whatever issue I have, whatever information I have, and I'm gonna fashion a remedy to be contained in the conditional order to dismiss. You understand that? So whatever issues you have between now and then, you bring them, and then I'm just gonna make a decision as to how we're gonna handle it and how it's gonna be handled in the future.
So do you want me to draft you one and then you see what we were thinking, the terms that we were thinking?
Yes, you can draft one that has the terms, but
No, I get
you know, but what I'm saying is, had I done this before, it wouldn't have included don't pull the fire out. Right?
Right, because
So-
that didn't happen.
Because that hadn't happened. So I don't know what's gonna happen between now and January 20th.
Yes.
But anything, and that goes for both sides, whatever issues the plaintiff has, bring them. I'm gonna just make a call on it. Ms. Melvin, you bring to me whatever issues you have, we'll look at it, and I'm gonna make a decision on it.
Can I have?
It would probably be my goal that when everybody walks out, I have a conditional order of dismissal and nobody is happy.
Who is she with?
Who is who
Adult
with?
Protective Services.
She's with Adult Protective.
Adult Protective Services.
She's the one that come out with the fellows to put your stuff in boxes.
That was the state of Michigan? That
Yes.
came with the federal marshal?
With the federal marshal, what?
Yeah. I got his business card.
All right. Okay, I don't know who came out there, Ms. Melvin. If federal marshals came out, you're way more important than even I am.
Why?
We need a time for January 20th.
And that's at 9 a.m.
What the hell did I do?
What do you mean, what did you do?
I don't need the federal marshal protected.
No,
and all that stuff.
Ms. Melvin, no federal marshals are coming out,
That has nothing to do with us.
all right?
Hey, Alex, do your thing.
This,
I'm calling on the Lord.
okay.
Did you come out, you came out, you're the one that came out to put all the stuff in the boxes with the workers, right?
Yes, sir. That was me.
You
What
didn't,
was that?
We spoke with Miss Melvin after the
Yes.
last court hearing. And then, well, two hearings back. We made arrangements for our resources to come out to assist with packing and to move things around. It did not happen that day.
Can I have your name?
It did not happen that day because Miss Melvin was not ready for us to proceed with that project. And at that point, that was when I called you, Mr. Melvin, for your help. And you've been consistently helping since then.
Okay, Miss Melvin, let's listen.
okay, yeah, I understand
Okay.
what happened.
My blood pressure is 200 over 100 for the last 5 weeks. I
Okay,
can't
okay,
sleep
Miss
that
Melvin,
night.
Miss Melvin,
What is happening?
okay, Miss Melvin,
What?
hold on.
What did I do?
You did nothing, Miss Melvin.
That,
All right, so here's what's gonna happen, Miss Melvin. Here's what's gonna happen. I'm gonna see you in January, on January 20th, okay?
My grandmother's birthday.
Okay, and maybe there's something to be said for it being that day. Okay, we'll see you that day at 9 o'clock. We're gonna get this all hammered out so that everybody knows how things are gonna work, okay? Miss Melvin, what did I tell you before? You don't need to get worried about this. Nothing's gonna happen until I say it's gonna happen to you, and I haven't said it. I made you that promise at the beginning. I'm gonna keep my
I
promise,
know you did.
okay? All right. Anything else? I'm not gonna ask that. I'm done.
We're done.
All right.
We're done. We're done.
Okay.
We appreciate you, Your Honor.
Thank you, folks. Ms. Young, thank you so much.
thank you, sir.
All right.
Can I leave a copy with you just? so-
Yes, you can leave it with my staff. All right.
Yeah, another seal.
Yes.
Thank you, Your
Ladies and gentlemen, that's it. That's all we got. Today we have some special outro guests. Say goodbye to everybody. Say goodbye. Just as the show is ending, the dogs decided to speak up. But hey, we've seen every other iteration of that court case. So I thought it was important to see that one too. Goodness. That's not right. Ladies and gentlemen, going to there we. That's a little better. Yeah, you tell them. Say bye, everybody. It's been a great show. Thank you to everybody who came to hang out. Chat was amazing. I do want to say before we get away, oh my goodness, the little puppies are going nuts. And for every little bark you hear, we're saying thank you, Jeremy Morrow. Thank you, thank you, thank you 5 times over. Julie, thank you 5 times over to Dory. Thank you 10 times around. Barry, thank you 20. And Eileen, 5 times the love, 5 times the appreciation. We do appreciate you. You people are amazing. I am your Lone Wolf Usul. I am your host. And I have been your curator for these here videos. I take full responsibility for the choices that have been here made today. But I hope you have enjoyed the cases as I have. And I hope you come by to take part in our live chats that happen every night of the week around 9 p.m. Eastern Time, 8 p.m. Central Time. And I'm here every Saturday at 11 a.m. Central Time. That's noon Eastern Times for these court time brunches. Thank you for coming out today. We'll see y'all next time. I'm your Lone Wolf Usul. I'm out. They say bye too. Bye.